SICAM vs. Jorge, year number 159617, August 8, 2017. Lulu Jorge owned several pieces of jewelry with Agencia DRC SICAM to secure a loan in a total amount of 59,500 pesos. However, in 1987, two armed men entered the pawn shop and took away whatever cash and jewelry were found inside the pawn shop vault. Spouses Jorge filed a complaint against petitioner SICAM for indemnification for the loss of pawned jewelry. SICAM filed his answer contending that he is not the real party in interest as the pawn shop was incorporated in 1987 known as Agencia DRC SICAM Inc. That petitioner corporation had exercised due care and diligence in the safekeeping of the articles pledged with it and could not be made liable for an event that is fortuitous. RTC ruled that petitioner corporation could not be held liable for the loss of the pawned jewelry since the loss of the pledged pieces of jewelry was occasioned by armed robbery, and that robbery is a fortuitous event which exempts the victim from liability for the loss. On appeal, CA reversed the decision of RTC. It held that the corresponding diligence required of a pawn shop is that it should take steps to secure and protect the pledged items and should take steps to ensure itself against the loss of articles, and that robberies and holdups are foreseeable risks. The issue is whether or not the petitioners are liable for the loss of the pawned articles in their possession. The Supreme Court affirmed the decision of the Court of Appeals. Under Article 1174 of Civil Code provides, except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. To constitute a fortuitous event, the following elements must concur. A. The cause of the unforeseen and unexpected occurrence, or of the failure of the debtor to comply with the obligations, must be independent of human will. B. It must be impossible to foresee the event that constitutes the caso fortuito, or if it can be foreseen, it must be impossible to avoid. C. The occurrence must be such as to render it impossible for the debtor to fulfill obligations in a normal manner. And finally, the obligor must be free from any participation in the aggravation of the injury or loss. The court said that robbery per se, just like carnapping, is not a fortuitous event. It does not foreclose the possibility of negligence on the part of wherein petitioners. The provision on pledge under Article 2099 of Civil Code provides that the creditor shall take care of the thing pledged with the diligence of a good father of a family. This means that petitioner must take care of the funds the way a prudent person would as to his own property. It revealed that there were no security measures adopted by petitioners in the operation of the pawn shop. Evidently, no sufficient precaution and vigilance were adopted to protect the pawn shop from unlawful intrusion.